ATF bureaucrats just issued a classification letter its leadership admits they weren't supposed to issue, but now the agency is refusing to rescind it. Today, we're asking why the ATF just classified an 80% handgun frame as a firearm using Biden-era talking points. All while Attorney General Pam Bondi's government-wide review of Second Amendment violations is ongoing. By the looks of it, ATF is back to its old trick, in spite of its promise that this is not the same ATF of the last 4 years. Hi, I'm Ben, and you're watching the Minuteman Moment. But before we get into the video, I just wanted to take a second to talk about how great it was to see all of you at Goals. It was awesome to be able to talk to GOA members from around the country. And it was incredibly encouraging to see how passionate and engaged so many of you are about fighting for the Second Amendment. Our Goals 2025 recap video is now live on this channel, so if you couldn't make it, check it out to see what you missed. Okay, now back to the video. Recently, a GOA member reached out to us with an ATF classification letter we didn't expect to see. At this GOA's members' request, we are keeping personal and identifying information to a minimum. But what we can say is this member is a popular manufacturer and retailer of firearm parts. Over 5 years ago, he submitted a prototype of an unfinished, or 80%, handgun frame design to the ATF for classification under federal law. Although this is not something most of us do, submission of new designs and product samples to ATF is a common practice for manufacturers and other industry members. ATF conducts technical evaluations of submitted samples and then responds to industry members with a written opinion on the sample's legal status. While it's not surprising that ATF took years to get back to this GOA member, what is surprising is that ATF issued a classification letter now of all times. Even more surprising is what ATF's ridiculous letter actually says. But first, some background. We all know that there are way too many federal gun control laws on the book, but they apply only to firearms, a term that has a specific legal definition. Federal law defines firearm to mean any weapon which will or is designed to or may readily be converted to expel a projectile by the act of an explosive or the frame or receiver of any such weapon. In other words, a lot hinges on whether ATF thinks an object is a firearm. For example, in order to manufacture or sell a firearm commercially, a person must obtain a federal firearms license and follow all of the record-keeping and background check requirements of the Gun Control Act. That also means all commercially sold firearms have paper trails that ATF can eventually access, digitize, and store. In fact, GOA reported that ATF has been doing this for years now, in violation of federal law and to the tune of 1 billion digital records of gun sales. Naturally, we gun owners value our privacy, so if there's a legal way to exercise our rights without Big Brother looking over our shoulders, we want to take part. Of course, anti-gunners hate the 80% industry. It allows law-abiding gun owners to keep themselves off of ATF's unlawful federal registry, depriving the government of its paper trail. But that also means anti-gunners have a massive incentive to broaden the definition of firearm as much as possible, to wrangle gun owners back onto the books. And that's exactly what the Biden administration tried to do. For example, ATF would now look at whether an unfinished frame or receiver is readily convertible based on vague guideposts like time to finish, ease of finishing, expertise required, equipment needed, parts availability, expense, etc. ATF's 80% rule also defined a firearm frame to be the part of a handgun that provides housing or a structure for the sear, designed to hold back the hammer, striker, bolt, or similar. GOA fought tooth and nail to prevent this Biden-era infringement from destroying the 80% industry. We filed a lawsuit in North Dakota, which is still ongoing. And when another case challenging the rule made it to the Supreme Court, we filed an amicus brief in support of the challengers there. But unfortunately, the Supreme Court upheld the rule on narrow grounds in Bondi versus Vanderstock. This means that, at least for now, the ATF's frame or receiver rule is here to stay. Even so, gun owners have reason to believe that the rule's days are numbered. During his 2024 campaign, President Trump stated in no uncertain terms, "In my second term, we will roll back every Biden attack on the Second Amendment, starting the minute that Crooked Joe shuffles his way out of the White House." And once he took office, President Trump issued a historic pro-Second Amendment executive order directing Attorney General Pam Bondi to examine all regulations to assess any ongoing infringements of the Second Amendment. To that end, Attorney General Pam Bondi initiated a review of all Biden-era ATF rules. And this includes Biden's 80% frame or receiver rule, we are told. Likewise, ATF recently promised us that this is not the same ATF of the last 4 years. We are fundamentally changing course. But that brings us back to our GOA member and their recently received ATF classification letter. And this is where things get really shady for the ATF. A couple of months ago, GOA asked ATF a question. What is the status of 80% frames and receivers after Vanderstock? Will ATF be taking a more pro-gun approach to these items? Hold tight, we were told. ATF promised that it currently is not issuing any 80% classification letters. But then, just days later, ATF did exactly what it told us it was not doing. It issued an unfavorable 80% frame classification to one of our members out of the blue for a product sample that had been submitted 5 years before. We brought this to the attention of ATF personnel, and they informed us that the sending of this classification letter was a mistake. Now, one would think that if the classification letter had been a mere bureaucratic oversight, a slip-up, ATF would have simply withdrawn the letter it admits should have never been issued in the first place. Despite repeated requests, ATF has gone radio silent, failing to withdraw the letter or even provide us with an update. Which is absurd, because in this classification letter, the ATF reaches some truly ridiculous conclusions. First, ATF's letter concludes that our member's 80% sample is a firearm because it may be readily converted into a working handgun frame. But there's just one problem. ATF never actually attempted to finish the sample to see if that was the case. How do we know this? Because after classifying it as a firearm, ATF reached out to our member to ask how the product would be completed into a firearm. Translation? ATF doesn't know how to finish the product. And that's hardly surprising, because our member explains that he even doesn't know how to finish the sample. It's just a prototype.
He never made a jig, never attempted to finish one, and never thought up a process to do so.
In other words, the item he submitted is entirely theoretical, and yet ATF claims it's definitely a firearm. We'd expect that sort of know it when we see it talk under Biden, but Trump's ATF is supposed to be a serious agency. Second, ATF's letter to our member completely misapplies its own frame or receiver rule. ATF bases its classification on the fact that the sample has a partially formed space where a person can place the trigger sear. ATF claims this place is highly significant, so significant in fact, that ATF calls it a critical area, where any degree of completion will make completing the rest of the firearm much easier. But this doesn't make any sense. In fact, it's downright dumb. Under ATF's logic, a person could machine a sear cavity into a large block of steel, and that would be a firearm, because the completion of this critical area apparently reduces the time, expertise, equipment, and expense needed to make an unfinished firearm functional. Even though no ordinary person could possibly hope to finish a block of steel into a firearm receiver, ATF says it's a firearm nonetheless, because the sear area has been formed. But what is a critical area anyways? Well, it's hardly ever mentioned in the frame or receiver rule. In fact, the term pops up only in other contexts in the rule. The places on a receiver to be marked with manufacturer engravings, and the places on a receiver someone should cut with a blowtorch in order to legally destroy it. In other words, ATF has now made up a completely new term that doesn't even appear in the rule it's claiming to apply. Third, ATF's letter to our member focuses on the wrong question. Under ATF's frame or receiver rule, the location of the housing for a sear determines what part of a firearm is the frame of a handgun, regardless of whether it's finished or not. But here, ATF is claiming that the stage of completion of the housing for the sear determines whether the item is a firearm. Those are completely different questions. ATF is still using this Biden-era rule as a weapon against industry members, all while the Trump administration has paused implementation pending AG review.
This can't possibly be what the president had in mind.
There are other serious problems and illogical aspects to ATF's unfavorable letter to our member. We don't have time in this video to cover all of them. But circling back to the biggest problem of all, why is ATF issuing unfavorable classification letters to members of the Second Amendment community? Why is ATF issuing 80% classification letters when it promised GOA it wasn't? Why has ATF refused to withdraw a letter it claims should have never been issued in the first place? And why is ATF classifying inanimate objects as firearms when its own experts don't have a clue on how to finish them? All of this makes it very hard to believe that this is not the same ATF of the last 4 years as the agency claims online. To the contrary, this is the same agency that in years past claimed that a water bottle is a firearm, claimed that a potato is a silencer, and claimed that a shoestring is a machine gun. It seems that ATF's ridiculous letter to our member is simply business as usual for this rogue agency. And this raises serious concerns about whether the new ATF does intend to act as good faith partners of the firearm industry. After all, we have no way of knowing when other members of the firearm industry might receive an anti-gun classification letter out of the blue. Are all force reset triggers safe? After all, DOJ tried to limit the sale of certain FRTs to rifles and not handguns. Are our 14.5-inch pin and weld safe if an ATF bureaucrat can break it in a vise? We're still waiting for ATF to abandon its position on imported pin and welds. We've tried in good faith to fix what should have been a small mistake. But we feel it's our duty to warn gun owners and our industry partners that rogue ATF bureaucrats are continuing to enact their anti-gun agenda. And as of yet, we have not been able to work with the Trump administration to clean house. ATF is long overdue for reform. Whoever issued this classification letter in the first place should be shown the door. And at a minimum, ATF should not be permitted to classify an unfinished frame or receiver as a firearm without first knowing how to finish it. That's a no-brainer. Now thanks for watching. Be sure to like, comment, and subscribe to stay up to date with the latest fights for your rights.